thank you everyone for coming today to practice Interruptions, essential tips for contingency planning. Right off the hop, I'll let everybody know that the slideshow is going to be attached to the recording, which will later be posted on the Law Society of Yukon's website. So you don't have to be writing everything down as quickly as you can. And additionally, there will be hopefully some time for some questions and answers from our panelists at the end of the presentation. So you can use the question and answer button at the bottom of your screen or the chat to myself, and we can turn to those questions at the end. So we have two great speakers I'm really excited to introduce. We have Donna Moore. Donna is legal counsel with the Practice Management Department at the Law Society of Alberta. She completed her law and graduate degrees at the University of Saskatchewan. She then articled and practiced in Saskatchewan, primarily in the north, with a focus on litigation, family, and criminal law. She relocated to Alberta and practiced with boutique litigation firms, advocating for predominantly Indigenous clientele. In 2014, Donna transitioned to her current role, where she engages with lawyers to provide support, resources, and consultations/assessments of their practice. Donna enjoys theater, exploring local farmers markets, and snowshoeing in the Rockies. But her real love is travel, having lived and worked in Central America and Africa, and she can't wait to re-engage that passion. She has two incredible children, 3 brilliant grandsons, and a tiny dog who rules her life. We also have Eleanor Platt. Eleanor is a Custodianship Counsel for the Law Society of Alberta. In that role, she oversees all custodianships over lawyers' practices in Alberta. Eleanor was the first articling student to article at the Law Society of Alberta. She became Custodianship Counsel after her call to the bar in 2019. Prior to joining the Law Society, Eleanor completed her LLB and LLM in England. She worked in human resources and then completed the NCA process. In her spare time, Eleanor enjoys skiing, hiking, and yoga. And the other face that you'll see on the screen is Kendall Moholitny. She's Senior Manager of Professionalism at the Law Society of Alberta, and she has graciously offered to help with the slides today. So without further ado, I'll turn it over now. Thank you so much.
Hi, everyone. Hi, I'm Donna, and I'm really pleased to be here. Thank you for inviting us. I'm here again with my colleague Eleanor and Kendall, and we're really excited to chat today about, the topic of small firms and critical planning. And this is something that we could spend hours and hours on. We've got some hopefully helpful tips and some insights for you. And we'll talk about, how things can be handled and planned for efficiency, and how to make things as smooth as possible for transitions for both planned and unplanned absences. We'll also try and share some thoughts about how to wind up a practice when there might not be much or any planning in place. And although this is more aligned with, small firms, sole practitioners, you might be in a firm or you might be at legal aid, and it might not be exactly on point, but there still might be some takeaways for you. Now, just to kind of get some of the language that we're going to be using, you might hear us say contingency planning. That's kind of the general, sort of phraseology. But Eleanor and I recently have had a lot of discussions about calling things more, succession planning, business continuity, to reflect the actual reality of what lawyers engage with and what we're seeing when we work with lawyers in our respective practices. Really, it's how things are going to operate if you're not there. So if you have to step away for a while, or maybe, you want to take some time off, you have to have someone pulling the levers until you get back, or managing the situation if you're not coming back. That's business continuity. There's also the succession planning piece, but really they're sort of one and the same in the sense of what you need to do and what you need to think about. So if you have questions, as Amy's indicated, we're happy to entertain those afterwards. And also our contact information is available for you at the end of the slides. Please feel free to reach out for questions or other refinements to what we're saying, or some of your comments. Would appreciate it. So why do I need a plan? Well, The slide indicates there are many reasons to plan. You've got obligations of your clients. You've got obligations to the court. You have ethical obligations. You've got a duty to ensure that clients' matters and funds are protected. Now, if you can't practice, who will handle court applications? Who will handle the disbursement of funds? Who will handle all of the day-to-day operations of your practice, your business? Remember that only a lawyer can deal with trust accounts and client files. And while you might have just excellent support staff, they can only help up to a certain point. But you have obligations to your staff. Who will deal with office expenses? Who will deal with paying them? Who will deal with covering the costs of vendors? You need to ensure that those payments are going to be made, and you have obligations above and beyond that. You have obligations to your family. So if money is not coming out of trust and you're in a hospital bed, who's going to make sure that the mortgage is paid? So you need a plan. But, you know, let's kind of deal with the context here. You're a regulated professional. You've got code of conduct obligations. You're a member of the Law Society. Even if you're inactive or retired, unless you're no longer a member, you're still bound by the code of conduct. And this slide sets out the relevant chapters of the code. They're paramount, right? You've got paramount obligations to your family, and you've got paramount obligations to client, colleagues, the court. Chapter 3 and Chapter 7 of where we'll focus today, and you can see what I'm talking about specifically on the slide. But I want you to think about those in the context of business continuity and succession planning, and making sure that you're going to be able to, you know, uphold your duties of competence, confidentiality, conflicts, and of course, the successor lawyer. So some of the situations we encounter involve lawyers that might be struggling with capacity. And I'm talking more about capacity in the sense of competence, not really if you're at your capacity in number of files or time, you know, dedication. This is really dealing with functional and cognitive capacity. And some of the situations we encounter, you know, involve a lawyer that is sort of moving towards losing competence, losing capacity over time. And that gives us a bit of insight into how to plan, but it's also a grave concern if the lawyer is unable or unwilling to engage and implement a plan. The concern that we have, though, is that it prejudices clients. It also impairs that lawyer's ability to supervise staff, monitor trust accounting, and deal with Law Society obligations. So the bottom line is a lawyer must withdraw if they're no longer competent to handle a matter. And when that occurs, that lawyer is obligated to minimize expense, prejudice to the client, and do all things to facilitate an orderly transfer, a transfer to other counsel. And of course, this is easiest done if there's a plan in place. So we're going to work with, you know, some ideas on how to manage that going into the situation that lawyers might not, sort of apprehend or appreciate is actually happening. But then we also need to address what happens when a lawyer suddenly departs or dies without a plan. And again, we see both circumstances happen frequently. In those cases, particularly where the lawyer passes away, staff and family are tasked with trying to address a lot of things all at once and do that while they're grieving, and they're not lawyers. So it's a situation where they really don't know what to do. In Alberta, we refer them to Eleanor, and she'll speak to you about that shortly and what her role and process is. But again, we've got to ground all of this in the context of the code. And when you talk about competence, you also have to consider confidentiality. And when these people are stepping in to take care of last minute tasks, organization, and file management, confidentiality can be compromised. It happens when there's no contingency plan. It happens when the files are changing. So both the lawyer with the plan and the lawyer being appointed as the designate have to be very, very cognizant of how to maintain these duties and how to implement them. Now, with respect to client property, the obvious vulnerability is, of course, the trust account. But depending on your practice, you might have other property. And again, all of those have to be corralled and managed appropriately so that staff, the designate lawyer, and the departing lawyer can hopefully all work together so that things are done properly and efficiently. But okay, great. All of that sounds really wonderful and awesome. But how do you put a plan in place? What do you need to consider? Just 3 simple things. who'll take over your practice? And that might sound simple, but it's, you know, that might be the hardest thing. But it's paramount to think about it now and think in terms of creative solutions of how you're going to acquire designate lawyers. Secondly, what will happen to your files? Third, what will happen with the business side of my practice? So succession planning is really, really important because those three questions have to be dealt with sort of in tandem. And we've got some helpful tips on making a plan and when to make a plan. And now let's talk about each of those respectively. So who will take over your practice? That lawyer, and it has to be a lawyer, must be active and practicing. If you have a trust account, the lawyer that will take over the trust account also has to be properly authorized and approved to do so by the Law Society. So in Alberta, they have to be designated as a responsible lawyer under our rules and the nomenclature there. The trust accounting team does that in tandem with the lawyer seeking to provide the designate. And they also engage with the lawyer who's purportedly, hopefully going to be stepping in. Only a responsible lawyer can disperse money from a trust account. Now, we understand that situation is likely similar for you, and we want you to take the steps now after this webinar and see, you know, what you need to do if you want to appoint a designate. But you also need to consider, and this is something to look at in your own circumstance, is how long does it take to get a lawyer appointed? There might be processing times for approvals. And in Alberta, those processing times include considering what time of year it is. If it's the time of year when all the lawyers are providing their uploads or status reports on their trust accounts, things might get slower. So have a designated alternate in place, step forward and see if they're going to be approved, and then consider what is, you know, what's the consideration for this? Is it something that you're going to enter into a reciprocal arrangement with your colleague? Are you going to pay him or her for their time and effort? And if so, where's that money going to come from? So maybe you want to consider having the discussion with your designate, whether they're willing to take over some of the files and take over some of the clients as their own. Again, you have to bear in mind that this might be something that has to be managed in terms of client consent. They have to consent to having the new lawyer take over. So then maybe that's not as much of an option as you might think initially. Maybe keep sufficient funds in your general account for emergency purposes. Maybe think about a line of credit in place for this particular matter. But you really need to make sure that you are considering who's going to take over your practice and then building in these other considerations. Are they willing to do it for whatever you're able to accommodate in terms of payment? Are they a practicing and approved lawyer? Are they going to be someone that trust safety is going to feel comfortable with? Maybe you have one person in mind, or maybe several people. Sometimes having several is a good option because of these other considerations I've just pointed out. Maybe consider networking with colleagues through other informal methods and come up for a strategy. In Alberta, we have a strategy called Locum Connect, and it's sort of a matching, as the name implies, where you can connect and search out locum opportunities or locum lists of who might be able to accommodate designated needs or temporary or planned absences. If the Yukon is, avails, or if you can avail yourself of that same platform in the Yukon, that's great. If not, maybe because of the fact that there are a number of Alberta lawyers also called in the Yukon, that might be an opportunity to sort of consider for these planned absences. Now, when we talk about planned absences, though, and I want to just take a brief minute to go over that on the next slide, there's a lot to sort of consider. When you think about planning an absence, what does that look like? Maybe you want to go on a temporary sabbatical, right? You want to go and explore life abroad for a bit. That's great. You might already have someone in mind who can step in and take over that practice, but you want to ask yourself, how long is that going to be? Because that triggers considerations of time, in addition to money, whether you want to take on additional files in anticipation of your absence. Do you want to maybe sort of start wrapping up certain things depending on what your practice looks like so you can generate income for that? So think about when will you come back? But also you can also consider maybe a temporary trial on retirement as part of your planned absence. And then you can see what it feels like to retire, and you can start to wind down in a more long-term way. And that's part of your strategic or contingency planning. So this is something to think about at this point too, because it's not all emergency planning. It's not all what happens if there's fire, flood, or disease, or you have to be called away to deal with something, you know, outside of Whitehorse or the Yukon. You can sort of navigate what winding down your practice long-term looks like on your terms. Then you need to provide up-to-date information though. Up-to-date information to whomever is stepping in, and up-to-date information to the Law Society about when you might want to come back so that you can think about the reintegration into your practice. But a planned absence is a good way to test out, you know, take things for a test drive, what you've got in place, and see how it works for you. But now we're going to continue on sort of looking at the second aspect of overall planning, which is what's going to happen to my files. Files are the bread and butter of your practice, right? That's where you generate your WIP, you generate your income, you generate your resources, you generate your next steps, but you've also got to deal with closed files. So active files, closed files, and even your trust accounting files all have to be managed very carefully all the time, but particularly when you're starting to think about planning for business continuity or contingency processes. So you've got the open files, the active files, all of those things that are on your plate right now. We like to suggest in the practice management department that lawyers use something called a master file list. On the slide, we've got it called an active list. Same thing. It's a list of all your open, active files, and it includes sort of, you know, when the file was open, dates of any upcoming court appearances, instructions from clients, regularity of communication. But you can also include WIP, AR, billing refresher dates, things like that, so that all of your practice is on one, you know, in one place. And this is good for you, it's excellent for your staff, but it also helps the lawyer that might be stepping in to take things over. It's all concise. You should also think about those inactive files depending on the nature of your practice. If you have a family law practice, you might have things that are sort of, you know, in between stage. Maybe you've got a custody order, but you anticipate there might be variation coming down the road, something of that nature. So make sure that the inactive files don't fall through the cracks. But again, all of this information is going to help the lawyer, you know what to do, know what's a priority, know what has to be handled immediately and emergently. Now for closed files, this is something that you can get a grip on now, even if you're at an early stage in your career. And if you're later on in your, in your practice and maybe you want to think about winding down, it's a good time to think about your closed files, because I can tell you right now, they're one of the biggest time needy whole parts of this process. And I don't want to say a time drain, because the work is very important, but it's very difficult to manage. You need to go through the files. You need to diarize for destruction. You need to make sure that things that are necessary to be returned back to clients go back to clients. For instance, original wills. If you're keeping original wills, you might not want to keep them anymore. Maybe you want to go through your original wills that are in closed storage and return them to the clients. You need to make sure that you do that so that it's properly recorded, acknowledged, the clients have it. Maybe you want to start editing out the files that can be stored digitally and scan them and upload them so that you can sort of reduce the costs of file storage. It's a huge financial expense. And for someone who might be stepping in to take over your file, active or otherwise, the closed files can be somewhat of a thing that they've got to manage that takes up more time than it's worth in some cases. We often find that lawyers are reluctant to destroy files, but if you can engage with the practice advisors, find out best practices for timelines for file destruction, manage that in conjunction with your plan, you're going to be editing and clearing up and cleaning out and saving yourself a lot of time and energy and expense down the road. Another thing to think about though is I've seen this firsthand, where we have a widow or a widower and they're facing having the Law Society come in to help them deal with their deceased partner's closed files at a time when they might not be at their best means to deal with this. That's something that you might want to consider. But in addition to that, Someone who might be navigating this in your absence might not be bound by the confidentiality piece. And that's a concern because, again, as lawyers, it's paramount. Now, for the accounting, try to keep your records and reconciliations as up to date and compliant with the Yukon rules as possible. This makes it easier for the lawyer taking over. It also makes it easier if you yourself are planning on winding down. Try not to have lingering inactive accounts. Deal with undispersible funds as quickly and efficiently as you can. Again, someone has to step in and do this if you can't. And so it's more efficient and it's less expensive if you have a nice clean roster for this all to happen. But we want to just quickly talk about the business side of your practice here too, because again, it's the day-to-day operation and business continuity is part of our overall consideration. You want to think about all the things that your business is currently addressing. And if there was a need for you to step away, or if there was a fire, a flood, something of that nature, all of that business content, all of that information should be housed somewhere for you or someone else to readily access and continue on somewhere else in some other capacity. So think about your billing, your expenses, your day-to-day costs, your vendors. Try to align all of these so that the lawyer stepping in can easily and readily take over. You want it to be seamless, but you also want to make sure that your files are being billed regularly so that you have low ARs, your billing frequency is on point, make sure taxes are up to date, have a prepared list that includes vendors, automatic payments for subscriptions, details on leases of equipment, etc. Try to keep a list of your creditors and inventory your hardware and software, right down to the versioning. If there was something that you needed to implement in terms of a quick, quickly setting up an office in a new location because of fire, if you have that readily accessible, you can go to your insurer, have the versioning and the hardware list inventoried and present them so that they can start work on your claim immediately. Put that information into somewhere readily accessible. I like two places, what we call an office manual, one physical, maybe one stored in the cloud, so that you or anyone else can pick it up and carry on as seamlessly and effectively as possible. But if we talk about some other things that you should do, again, you always want to contextualize it in the sense of having someone step in and take over so that the client's interests aren't prejudiced and the lawyer that's working on your behalf is doing so as effectively and productively as possible. Have that useful contacts list prepared. And useful contacts includes your lawyer, your accountant, your bookkeeper, your banking details. Have that all up to date and readily available, and also have it accessible to the Law Society. You need to have them informed about your status because, again, we're regulated, but if something were to happen to you, often clients might go straight to the Law Society to find out where their files are. And if there's that information available to them, it makes it a lot less stressful, makes it more seamless. And again, I can't emphasize how important it is to those people who are working on your behalf, making sure that this is all managed properly. One other thing about working with the Law Society on this piece is that it's really to your benefit because it also ties in with all of the things you need to do. Trust safety, membership status, that all works really well when you're engaging with your Law Society in a proactive and lockstep kind of measure. We like to do that often in practice management when you have a lawyer who's looking at going inactive or maybe transitioning towards retirement. We'll sort of coordinate membership, trust safety, and practice management processes so that the lawyer gets the full benefit of all the Law Society can offer. So for instance, if your fees are due on March 15th, March 30th, whenever, and your insurance is due June 30th, maybe you want to engage with the Law Society in a proactive way so that you can time your departure from practice, transition to inactive status, so that you might not have to pay the fees. We want to work so that you can be as coordinated as possible. Similarly, with insurance, if you're not going to be practicing say for August, maybe we can move the date up on your departure and work more seamlessly and efficiently so that you don't have to pay the insurance fees by June 30th. So planning is now. Planning is really important in the sense of how much you have to do to manage your departure. Planning is really important in terms of what things you need to consider in case you can't actually affect the plan. But you want to start now, because cleaning up closed files, dealing with undisbursable trust funds, planning the timing around when fees and insurance are due, those are years to more ahead of time. You need to start thinking about that, and we're really happy to help you. In fact, we have a resource on our website that we've developed for Alberta lawyers, but it's really quite beneficial to lawyers in all jurisdictions. It's a manual, it's interactive, and it's entitled "When Bad Things Happen to Good Lawyers." Again, it's on our website, or you can reach out to Eleanor or I, and we'll be happy to send you a copy of the manual or the link to it. It's got numerous interactive templates and tips that you can modify for your specific needs. But it's also a good place to start, having this internal dialogue with yourself about what you need to do and when. But here's the big question. What happens if you don't have a plan? I can tell you right now, having a plan is just one of the best things you can do for yourself. You'll sleep better. Your family will know that they're taken care of. Your staff will appreciate it, and so will your colleagues. If you don't have a plan, the time and effort it will take by others on short notice and under what are often, stressful times, which can prejudice clients, be costly, and even result in potential breaches of the code obligations, makes it worth putting in the time on the front end. So I'm going to turn it over to Eleanor now for this part. She's got lots of insight and wisdom.
Thanks very much, Donna. So in Alberta, if a lawyer does not have a plan in place or cannot find a suitable lawyer to take over their practice, the Law Society can appoint a custodian over their practice, which is where I come in. A custodian is the one who will take care of clients and the funds that are in trust. But a custodianship isn't always the best way to handle things for various reasons. It can be quite expensive, but perhaps also no such service is available. So for that reason, you should plan ahead. Maybe you have a few lawyer friends in your area who could assist with the management or wind up of your practice, and maybe they could act as the sort of informal custodians of your practice. In Alberta, we say that a custodian is stepping into the shoes of the lawyer that is under custodianship. We would appoint a custodian either by way of court order or by undertaking. So I've got a couple of sort of high-level examples of situations in which the Law Society of Alberta has stepped in to appoint a custodian. So lawyer A suddenly passes away, and lawyer A has a close friend who is lawyer B, who's happy to take over the law practice and wind it up. But there's no plan in place. Lawyer A is the sole signing authority on the trust account, and the trust account can't be transferred over to lawyer B. Someone has to navigate the process required to have lawyer B take over as custodian and facilitate the changeover in signing authority with the bank. That's where the Law Society would come in. Similarly, lawyer C starts winding up her law practice. She becomes administratively suspended as she forgot to pay some fees to the Law Society, and that's due to health reasons. Her health deteriorates further, and she's unable to finish winding up her practice. There's no plan in place, and she doesn't have anyone that can take over her practice. This requires rapid and focused efforts to have someone or several individuals take things in hand. Of course, while it can be accomplished, there's time and effort that could really be utilized elsewhere. The power to seize a member's practice with a court-ordered custodian comes from Section 95 of the Legal Profession Act in Alberta. And Section 95 gives a list of circumstances in which the court can appoint a custodian in Alberta, and these circumstances include disbarment, suspension, death or mental incapacitation, illness, or for any reason the lawyer cannot practice, abandonment of practice, which includes abandonment of closed files. If the files are in arrears with a storage facility and the lawyer doesn't pay, that's another reason we can seize a practice. And also, if there's reason to believe that trust money held by that member is not sufficient to meet their trust liabilities. You'll find in Section 110 of the Legal Profession Act in the Yukon, there are very similar provisions. We do have approximately 12,000 lawyers in Alberta, and most Alberta custodianships are over sole practitioners. Even though we have a dedicated custodianship department, we still try to exhaust all other options and keep custodianship as a last resort. In the next couple of slides, I'll talk about what a custodian does, but this can be applied to any emergency situation, whether there's an official custodian in place or another lawyer who's just informally taking over your practice in the short or long term. So emergency situations, what does a custodian do? So there's a couple of really key things to note here. If you have another lawyer step in as custodian in an emergency, there's different options for what they'll be doing. They might need to wind up your practice. In that case, they'll reconcile, disperse, and close trust accounts, and active files will go to new counsel. If it's for short term or on perhaps more of a temporary basis, then it's more a matter of that lawyer managing the practice. So in that case, the lawyer who will handle the practice does it for a defined period. So they'll send files to new counsel and disperse from trust, but only where necessary. And then once you come back to practice, you get the practice back. And any sort of emergencies can be handled by this lawyer who's managing the practice. But if you have a plan, you can better define the activities and roles that that lawyer will do. So the lawyer taking over could be given the authority to deal with the business side of the practice. Again, that depends on having signing authority in place, but it's an option. Having a plan in place also allows for a smoother transition for clients, your staff, perhaps your family, and even creditors of your practice. For example, if a client matter cannot wait until your return, or if the practice is being wound up, you could build into your plan that the lawyer taking over would become client's new counsel by private retainer. Of course, that is by agreement with the client and depending on whether or not there's a conflict. If there's no conflict, then probably not. Also, you can think about the following tasks that might be left to whoever's managing your practice in the short term or in an emergency. So dealing with the landlord or an office lease, dealing with any outstanding payments to vendors and creditors. If the practice is closing down, perhaps terminating the employees. So there's quite a few different things that you can build into a plan. Files and trust account are definitely the big ones, but there's more than just files and trust funds that you can build into your plan, and you can really tailor it for your practice. And now I will hand it back to Donna.
I'm going to go back to the code discussion again. And this is really, again, I can't impart how important it is because it's going to underpin everything that you do in your plan. And it's also going to underpin what the custodian or the lawyer stepping in is. And Eleanor's outlined sort of how that might work and the role that that lawyer might have if they were to be winding down your practice. But the custodian also has ethical obligations. So under the Yukon Code, he or she has to take over certain obligations. And 7.13 requires a lawyer to report another in certain circumstances, unless doing so would be unlawful or involve a breach of solicitor-client privilege. And again, the reason is to protect the client interest. So the custodian has ethical obligations, and one of those includes monitoring what the lawyer they're taking over for might have been doing or might have been at, and this might circle back to our conversation about competence. Maybe there were things that were starting to erode, and it's only become apparent once the custodian comes in, and that custodian has ethical obligations too. Where there is a problem, the outcome for both the lawyer and the clients, the custodian lawyer, will be better if it's caught early, because those minor breaches might disclose a more serious problem. So all the lawyers involved, the one stepping away, the one who might no longer be there, the one who's stepping in, this all has to be managed very carefully too. And the reporting piece is code obligation. The question on whether to report another or not, though, is something that I just want to sort of indicate can and should be run past a practice advisor because these are nuanced. And a lot of the questions that you might be having arising out of this part of the discussion and our next step, which our next piece is on conflicts. Think about the practice advisors for, running the real nuanced and tricky situations past, because they encounter this daily and they can assess and advise very on point for your particular situation. But I'm talking about this because we do see a lot of lawyers who are moving away from the practice or navigating difficulties in their practice because of addictions, physical, mental, or emotional conditions, and so on. And so the conduct triggering a possible report can come out of some of those circumstances as well. And one question that we often get from a lawyer who might be stepping in as a custodian, or a lawyer who's looking to depart because it's just time, is, will there need to be a report? And if it's an addiction issue, one lawyer is required to report another if they are aware of an addiction. But generally, if a lawyer is struggling with drug use and is seeking assistance or making a bona fide effort to seek help, then there may not be a requirement to report them. So this is something to really sort of navigate as we talk about the ethical obligations. However, if you have reasonable grounds to believe that the lawyer does have an addiction and you are aware that the clients are at risk, even if the lawyer is seeking assistance, you should still engage the practice advisor and consider a report, because again, it's all grounded in the obligations and client interests paramountcy. So that's just that touch point on that, and to contextualize where we're going next. But now back to you, Eleanor.
Thanks, Donna. So what might seem like a complex and stressful process might be more straightforward than you think. If you don't have a plan in place right now, or you might have struggled to find a lawyer who you could approach as your sort of successor lawyer, as your chosen lawyer in your plan, I thought I'd bring a few ideas based on some alternatives to custodianship that we found in Alberta. So each one of these bullet points has sort of a little story, so bear with me. So firstly, former student. So we had a lawyer in a remote town who suddenly passed away. The lawyer was a sole practitioner and he had a very varied practice. The Law Society actually suggested to the estate that perhaps the lawyer's former student at law, who was recently called to the bar and had just set up on his own, could maybe step in and help close down the practice. There's no plan in place. We thought we'd think outside the box on this one, and the student had very recently been practicing with this lawyer, so it seemed like a good fit. The estate already knew the former student, and the estate and the former student agreed. The former student got some business, some new clients, and actually the assistant joined the former student. So the arrangement was beneficial to the estate, the assistant, clients, and the former student. We did have to appoint him as custodian, simply because there was sole signing authority with the lawyer that had passed away. But otherwise, that was all we had to do. So perhaps thinking of sort of former colleagues that you've worked with, former students at law. We had another situation in which a lawyer died very suddenly. That lawyer was a sole practitioner who space shared with another lawyer and had a varied practice. The files actually ended up being split per practice area, with different lawyers taking on different groups of files. There was an alternate lawyer assigning authority, so we didn't have to appoint a custodian. So this one's a good one to think about, particularly when we start looking at conflicts, which is coming up in the presentation. There's different ideas. Instead of thinking of it as all the files have to go to one lawyer, kind of piecemealing might not be the way you want to go, but if there are conflicts, maybe that's a solution for you. We also had a lawyer who passed away whose daughter is a lawyer. She was recently called and she was unsure what kind of practice she wanted to start. And she actually took over the lawyer's practice and we didn't appoint a custodian. We had another lawyer who was suddenly admitted to hospital. The Law Society was prepared to appoint a custodian because there was no plan in place and no one available to take the lawyer's files. But following discussions with the lawyer's family, one of the lawyer's long-term friends and colleagues from law school actually offered to take on closing down the practice. He worked with the bank, the family, the Law Society to facilitate this change and to sort of wind up the practice. So there's many alternatives to custodianship. Regardless of which lawyer takes over your practice, as I mentioned, it's important to be alive to conflicts and ensure that appropriate conflict checks are completed on your files. So I'll hand it back over to Donna, who's going to discuss considerations around conflicts. Over to you, Donna.
Yeah, I love how Eleanor has all these like stories, and then I have to dive into the nebulous, deep, dark, murky stuff again. Anyway, conflicts of interest. I kind of like the nebulous, deep, dark, murky stuff about conflicts because it is so important. Conflict management is paramount, whether you're just cruising along in your practice as is, or you're thinking about who might step in and take your files in the event of you winning an all expense paid trip around the world, and then you get to go away for 6 months and someone's coming in to take charge. But the thing about conflicts is that the issues particular to certain jurisdictions are pretty much consistent across a lot of the files that we see in Alberta, and managing conflicts when contingency planning is something that we can sort of share in terms of the overall principles and concepts and the necessity. So if there's a substantial risk, like what is a conflict? If there's a substantial risk that a lawyer's loyalty to or the representation of a client can be materially or adversely affected because of the lawyer's own interests or the lawyer's duties to another client or a former client or a third party, bam, you have a conflict. And Yukon, your code has 3.41, and then the commentary is at paragraphs 1 and 2. Alberta, it's similar numbering, similar wording. But basically, a client's interests can be prejudiced or compromised unless the lawyer's advice, judgment, and action on the client's behalf are free from conflict, right? So the conflict, though, it can come up at the onset of a file. It can come on during the course of a file. It's not a one and done duty. So you've always got to be vigilant and maintain, some oversight of files and who's going to be taking over files because of this, sort of progressive thing. As the retainer continues, new circumstances can arise, new information will be learned, which can establish or reveal a conflict of interest. So again, you might have a group of lawyers, a single lawyer, a cadre of lawyers who you think you can draw from. But when it comes down to it, ultimately, if you're not in a position to assess the conflict, the lawyer stepping in is going to have to do that. So having your files papered, having your practice as clean and neat and organized as possible will really facilitate that lawyer being able to articulate and explore the whole conflict piece. But I just want to talk now about the duty of loyalty, because that's also part of this whole conflict discussion. We all know that the lawyer-client relationship is a fiduciary one. So there's no disclosure of confidential information. You have to avoid conflicting interests. You must be vigilant to avoid conflicts of interest. You must adhere to the client's cause and uphold your duty of candor. Where are we going with all of this? Well, the Yukon Code spells out, in the commentary 5 through 9, the whole requirement for confidentiality, the whole requirement to maintain vigilance over conflicting interests. But can you act in a conflict? And this is kind of, where we're getting down to the nuts and bolts of practicing in a place like Yukon or even in Saskatchewan, where depending on where you're located, depending on the nature of your practice, the lawyers that you can draw upon for your, for your alternate or your designate might be limited. So if you appoint a lawyer as your designate and the day comes where he or she has to figure out whether they can take things over, can they act in a conflict? So if we hop forward to the next slide, there's a couple of pieces to consider here. You can possibly, right? If there's a conflict, we all know that there's ways to manage it in certain circumstances and in certain contexts. Now, your rule is 3.42. Ours is the same. The wording is essentially, essentially the same. Basically, it is possible to act in a matter if there's a conflict, provided the clients are not opposing each other in the same matter. If they consent, both or all, depending on what's happening. And consent means full voluntary consent, right? Now get that consent in writing. Advise the clients that they can seek independent legal advice on the conflict retainer. Document everything, including the recommendation and the client's decision, and make that your invariable practice generally. Okay, so advise, document, record, store on your file, because if you do it in anticipation of what your plan might look like when it's implemented, then the lawyer stepping in can hopefully rely on that, that disclosure, that discussion, that record. Remember too that adequate disclosure of the dispute requires full and fair disclosure of all material elements. So that facilitates the client making informed decision. The duty of candor is relevant here. Let's go back to that whole fiduciary candor. If you're not being candid, and then the client can't give or won't be seen as giving informed consent, then acting in a conflict is prohibited. So again, you can manage these situations if you think about all these factors in the analysis and put measures in place, including candid disclosure, full and complete disclosure, recording of consent, recording of what you've told the client, and then storage on the file so that it's readily and easily accessible. But, and here's the but, where it's not possible to provide the client with disclosure because of the confidentiality of the information of another client, then it stops, the whole thing falls. The lawyer can't act. So that's the consideration. Can that disclosure be made? But then we've got implied consent and acting against a current client. So again, under the rules, you want to look at 3.42. There's commentary in paragraphs 1 and 6. Where a lawyer represents numerous clients, there may be express or implied consent to that lawyer acting for multiple parties simultaneously. And again, exceptional, big, bold letters. This is an exceptional situation. For example, it might be appropriate to imply consent when acting against large institutional clients like banks, government agencies. But you know what? You still have to go back to the particular terms of the retainer and the particular circumstance and the particular context and the client. And you can't just make that overall assessment that because you're in this location with this context and this particular client, you can just act if there's a conflict that's identified. The lawyer must consider the nature of the client, terms of the retainer, any unrelated matters, and you must look at it objectively, because ultimately you don't want to add to the whole stress and the transition of implementing a plan by maybe misstepping on a conflict issue. So you must be sure that you can objectively conclude that the client commonly accepts that the lawyer may act against it. Navigating conflicts is an essential part of this whole process, but it's also very nuanced and very it's very tailored. You need to make sure that you've got the fact-specific analysis in place. Now, one last thing about implied consent. We'll just hop forward on the next slide because it's got some content there dealing with smaller centers. And I say smaller centers, even in Eleanor's articulation of some of the samples, there was the one lawyer that she mentioned whose students took over because he was in a more remote area. Same thing, not a lot of lawyers to draw from in the pool. And we see this in Alberta, and I've seen it in other contexts. We need to ground ourselves, though, again, in the rules, because even though there may be fewer lawyers to draw upon to seek out your alternate or your replacement, we're talking about trying to manage safe and proper file and practice management in your absence, death, departure, sabbatical, world travel, whatever. There may be fewer lawyers, active lawyers in private practice. That's the simple reality. But the code 3.42, commentary 6 addresses this specifically. And there is a factored analysis that goes into this. There may be a sense, that having fewer lawyers available is going to enable someone to act in a conflict, but again, you've got to manage it appropriately. But by necessity, you still can't act outside of your code obligations. And the availability of lawyers or legal services alone doesn't drive the analysis. It's simply a factor to consider. So I'm going to put this out there. And Eleanor's kind of alluded to it already in her anecdotal pieces. The profession's adapted to meeting remotely and over video conferencing for the past couple of years. And I think it's been a rocket fuel to a lot of things in terms of growth of the profession. But while it's not ideal in all circumstances, we are cognizant that lawyers and clients don't need to be in the same place. We know that now, we get that. Now, this opens up the possibility for retaining counsel to act on your behalf in these plans from a different jurisdiction, particularly if they are called in your jurisdiction. And that's one of the things that we are aware of dealing with Alberta, BC, and the territory. You can include this in your conflict analysis, right? Now, I understand and I appreciate that added to that analysis is also that technology and reliable internet may still be a challenge for some locations and members of the public. And, that's another piece to tailor into the whole problem. But where I'm going here is that as lawyers, we need to do the analysis, consider all the options to be code compliant. And we also need to maintain our obligations to our clients and their interests to have a plan. So at least having a plan in place, relying on the new world and the new reality and technology and thinking outside the box is really going to help develop that plan. And that plan is really important. It's important to you for your peace of mind. It's important to, as I've mentioned, your colleagues, your staff, and your family, but it also helps instill confidence in the profession. So that's all from me. I'm going to turn this over to Eleanor again.
Thanks, Donna. So when it comes to executing a contingency plan, a business plan, the first step, as Donna said, is to check conflicts. You should be aware of any files where the firm that needs assistance is on the other side. So as Donna spoke about in her conflict slides. But if you're working on developing a plan with your chosen lawyer, both offices should work together to identify files where there's a conflict. Once identified, send those files out to a new lawyer. If the conflict is something that cannot be resolved, you cannot get consent for whatever reason, send the files out to a new lawyer. You'll also need to think about conflicts when you make your own plan, but also if you're taking over for another lawyer. So thinking back to our alternative arrangements slide, as I mentioned, dividing up files based on a practice area can sometimes help you identify conflicts as you're making a plan. Client interests are key here. We've said throughout this presentation, clients are important. So ensuring that their file can be sent to another counsel with no conflicts also allows for a smoother transition for the client. If they keep you're playing pinball with the client, sending it to this lawyer, no, there's a conflict, no, this lawyer, there's a conflict. Having the plan in place and double checking those conflicts can help the client in terms of a smoother transition of their file. So what are some problems arising when we don't plan? So practically speaking, in a word, not having a plan can result in chaos. We at the Law Society of Alberta, we receive calls from staff, from family members, from other lawyers. And these are people who are dealing with grief, stress, anxiety. As lawyers, some of them might have their own practices to manage, and they have to keep that other lawyer's practice in the air. So it's inevitable that balls will be dropped. As bad as it is to have a lawyer being suddenly absent, when you add compromised client interests, it only gets worse. We've received phone calls from staff who are coming into the office the day after a lawyer has suddenly passed. They have real estate closings. There's no one to do them, no one with authority to release funds from trust. Clients are waiting with moving vans to get keys, and no one can act on this file. So all of this can actually result in a claim against the lawyer's estate. One of the examples of a ball being dropped. For members of the defense bar, an unplanned absence with no contingency plan can lead to missed court appearances and chaos while the court and the lawyer's family and friends try to find someone who can take over these matters. In the meantime, clients might be held in custody longer than they otherwise might not be. In addition to calls from staff, we also have calls from family, as I mentioned, who have no idea how to run a practice. They cannot cope because of the trauma of the lawyer's death. They're dealing with their own grief. There's files that need immediate attention. So there's all these layers. It gets very complicated, and it can be quite a lot for family members, staff, etc., to deal with. Although staff might have some idea as to what needs to be done, they might end up working with the prospect of delayed or no paychecks because there's no one there to run the practice. So that's sort of boots on the ground. This is what we see when we see that a lawyer doesn't have a plan. So in short, planning is key, and it's never too early to start planning. And thank you very much for joining us today.
Okay, thank you so much. I know for myself that generated a lot of great thoughts, and I see that we already have a question, so I'll just read it aloud, and then I'll leave it to yourselves, Donna and Eleanor, to jump in. So this one's from Darcy. They write, "You suggested working with the custodial lawyer to identify conflicts. This would seem to require identifying the client in advance. But identifying the clients you act for is a breach of confidentiality. So how can we identify clients in advance without breaching confidentiality? Does this require a blanket disclosure with all clients that the lawyer will be disclosing the solicitor-client relationship in advance with a custodial lawyer, or is there another better way to do it?"
Eleanor, how do you deal with that in your practice? I'll let you go with that if there's something you want to, and then I'll jump in if I've got my ideas.
So from a Alberta custodianship's point of view, we ask our external custodians to do conflict checks with the lawyer's name rather than sort of each client. So the conflict check with a custodian is done based on whichever lawyer is requiring their practice to be seized or managed or whatever. We do the conflict check there. In terms of if you are planning and how to deal with that, I might turn that over to Donna for some practice management tips.
Yeah, and again, that kind of goes back to it being a real fluid thing, and then it can arise during the course of whatever. And I've worked with some lawyers who started the plan and then realized that it was, you know, the lawyer that they had in place was not going to be able to be their replacement lawyer because suddenly they had too many conflicts. Sometimes it was a matter of the lawyers just knowing because they'd seen each other on opposite files and things like that. When it comes down to actually identifying the conflict ahead of time, it's a little trickier. You might want to navigate that on a client by client basis, depending on your practice and your files, saying, you know, I'm going to be going away in 6 months and I'm taking time off and I plan on having this person step in. You still need the client's consent anyway if he or she is going to step in. So that's going to help sort of filter through that confidential divulging confidential information question. But that's why planning kind of is really helpful on the front end, because you can say to the client, I think I'm going to have lawyer XYZ come in. Are you okay with having that happen? And it might just fall away anyway. But in terms of managing it otherwise, you can talk to the practice advisors. They've got some language and some processes. You could potentially say to a client in a retainer or part of their ongoing retainer, if I'm going somewhere, you know, as part of my due diligence to you and taking care of you as my client, I make sure that there is and again, this is the full informed consent. I make sure that there is a lawyer in place in case there's an absence. You know, this is who the lawyer is. Are you okay with me divulging certain pieces of your name and information and aspects of the file to weed out? I mean, things like that to navigate it. It's a little bit more work and a little more deeper. Practically speaking, it works out in reality, when somebody, is articulating to the client that this is going to be how it is, and are you okay with it, they generally, it's kind of like a non-starter in some cases. But ultimately, yeah, that's a really good question. Practice advisors deal with that specifically on what exactly can be released. And I'd say for your own specific circumstance, they'd probably be able to give you a more targeted response. But yeah, those are the two things that we see most often.
Thank you. So we have another question from Lynn from our Law Society. Do Alberta lawyers have insurance specifically to cover the costs of someone taking over the practice?
No. And that is something that I'll be candid. I came to the Law Society and I knew about custodians, but I didn't realize that ultimately the costs for the custodian were not borne in some way by insurance or by the Law Society. In fact, it comes out of the lawyer's practice or the lawyer's estate. And I've worked with a lawyer, for instance, who he was an older gentleman in a smaller center, and he had a health problem that took him out of the practice for 6 months. And he had someone in the community step in and operate it for him. And then he didn't realize that not only was that he did it to maintain his client obligations, but he didn't realize that the Law Society would, as Eleanor's articulated, come in, wind down the practice, or rather the custodian appointed by the Law Society would come in, wind down the practice, disperse all the trust funds, so that after 6 months, when he was ready to leave hospital, come back into the practice, he wouldn't have a practice. But just because he was maintaining his obligations, he had somebody run it for him, take care of everything, he could come back. He still had like 40, 50 active files. He could maintain his lifestyle, his bills, pay his client, or pay his staff, all of that thing. But yeah, there's no insurance, there's no fund, there's no, you're on your own. That's why planning is so important.
I'm just looking if there's any other questions. I'm not seeing any right now. So I guess just on that note of planning, how early is too early to start planning, would you say? Never too early?
Today.
Yeah.
Start today. And again, sort of anecdotally, when we went into a number of lawyers' practices to help them transition to winding down, they had 3,000 original wills and, C-cans full of files, and just that itself took months and months and months to navigate so that they could move forward. Now imagine if a custodian has to come in and do that, the cost, the effort, the time, all of that. Start now. And even like things that you don't think are going to take as much time, they generally do. Even getting that signing authority, getting that responsible lawyer or alternate on the trust account designated can take more time than you expect. Eleanor has seen this time and again.
Yes, I've seen some practices that have 500 boxes of closed files and there's been no destructions for 30, 40 years. I see lawyers that they sort of had too many files for one lawyer. There's no appropriate diary system, there's no file list. The custodian goes in and you sort of have to talk to the assistant and say, what he's doing first. So the sort of recommendations that Donna made, like having a file list, having an alternate, these things can definitely assist keeping up to date with your destructions, keep up to date with your closed files and arrears if you're storing them off site, things like that. Yes, I have many stories.
Yeah, and it really does help to have this all in a consolidated, and I call it an office manual for lack of a better term, but it's a training manual. It's a cache of all your important information and content. And I'm saying this because I've seen lawyers. I worked with a lawyer who had come out of a situation where he had to flee a fire, and he's sitting in a hotel room in another city calling his insurer, and the insurer says, well, can you send us a copy of your insurance certificate? And he's like, oh, I heard from the Law Society to take a copy of my insurance certificate, scan it, and upload it to the cloud. Here you go, even though that insurer should have had a copy of the certificate. Similarly, he had a list of all his equipment, all his desk, his software, everything, and could turn it over. Plus, he was also more nimble. He could start practicing again. And he was like, listen, I'm the lawyer that picked up and I'm still on the file for you. Fire, flood, pandemic didn't shut me down, I'm here as your lawyer. You know, it's a win-win in a lot of ways. But yeah, those things that you don't realize, that the insurer wouldn't start the claim until he produced the certificate. Odd, but this is the nature of the beast. We're lawyers. We see all kinds of things happen, right? Be prepared.
Thank you. Another question from Lynn. Is it a good idea for custodians to meet the staff?
Yes. I would say in my experience, staff are an excellent resource. So if you don't have a file list, but with this presentation, you know that you should have a file list. But if, let's say, a lawyer doesn't have a file list, an assistant is a great resource as to what's coming up, what's recently come in, what's recently closed, what real estate closings are happening tomorrow. So yes, quite often an assistant can be an excellent resource for a custodian. Quite often they're very cooperative. They are sometimes dealing with, as I mentioned, their own grief, their own trauma, their own anxiety over, I've worked with this lawyer for 40 years. I'm grieving the loss of this lawyer, but I'm also anxious because I could lose my job because this lawyer is now deceased. So it's sort of, there's many things to unpack. But I would say, yes, an assistant is an excellent resource.
I was just thinking, Eleanor, when you're giving the examples of in real estate situations where people are waiting to get into their house and things like that, how long does it take if there's no one set up to take over the practice and the Law Society is in a position where they have to intervene? How long does that process take?
So from my experience, I'll have to do this in two parts, pre-COVID and during COVID. So pre-COVID, as soon as we learn of a lawyer passing away or someone's in hospital, or we get these calls from staff and sort of lawyer friends, etc. I can then go to court with an affidavit and a court order and get a custodian in place. And sometimes it can be sort of the next day. During COVID, as everyone I'm sure has realized and can appreciate, that court processes have changed a little bit in COVID. So sometimes it can take a little bit longer, just depends on sort of the court that I'm going to, the backlog they may have. But often I can get a custodian in within a few days. If there are real estate closings, we'll sort of say to the staff to handle things as best they can, because although only a lawyer can deal with the funds, there are things that staff can do to assist with a real estate closing. But things take as long as they take. We try and get in as soon as we possibly can, but sometimes it can take a few days to get in.
Thank you. We have another question that came in. What is the average cost of a custodianship?
So I can answer this in two parts, because I will first say that the average length of a custodianship is approximately 3 years. So from first appointment to the trust account is closed, the general funds are dealt with, the files have gone, everything's closed, end is 3 years. The average cost that I have for custodianships in Alberta is approximately $90,000. Which is another reason why we're saying planning is very good, because in Alberta we do have the ability in our act to recoup the costs of a custodianship from a lawyer or their estate. So I mean, it might not, we might not end up getting funds back from an estate if an estate is insolvent or there's several $100,000 owed to CRA or something like that. We may not get costs back on a custodianship, but it is there's a hefty price tag to a custodianship, because a lawyer, the custodian will step in and they'll deal with files, they'll deal with clients, they'll deal with opposing counsel. They might terminate the office lease, they might deal with creditors. There's sort of a list as long as my arm as to what a custodian might end up doing. And if there's pushback from a client, or the custodian has to sort of tidy up messes, if there's regulatory problems, it can soon sort of rack up the cost, if you like. But yes, it's definitely Yeah, I'd say the best advice I can say is what we've said all along in the presentation is plan ahead, plan ahead, plan ahead as best you can.
Thank you. Donna, you talked a little bit about practicing in various jurisdictions, and I'm wondering if that's pretty common. For example, people practicing in Alberta as well as Yukon, and I'm wondering if it would be a strong recommendation or a good recommendation to have a lawyer who's also practicing in the same few jurisdictions to take over.
Well, yeah, there's a number of considerations there. Again, it depends on what kind of a practice you have. If you are, you know, and I'm sort of going back to when I was doing the work with the Indigenous communities, and we could work in different locations as well. So we often did, you know, sort of interact with lawyers in different jurisdictions, and they would understand the file, maybe they would understand the client, things like that. There is some, and I did a brief survey looking at the Law Society and other places, you know, the external facing website of the Yukon to see where other lawyers might be called. There is some overlap. And it is something that I've canvassed with the practice advisors in terms of strategizing for some of these scenarios, even and again, I've talked about practicing in Saskatchewan and some of the border areas and making sure that there's some consistency. But again, you have to have someone who's competent in the areas. You have to have someone who understands the practice area, someone who can is comfortable managing your practice. If you've got a brick and mortar office and 5 staff, that might not be as easily accessible for someone who might be in Hay River or high level Alberta to step in and interact with your staff on that that level that they need to build rapport and deal with the clients. It really depends. I mean, if you are fortunate enough to work in a place where you've got a colleague or someone who can step in immediately, that's ultimately going to be your best resource, right? Barring the conflicts issue. If you have to expand your circuit wider, then you do what you have to do to accommodate the client's needs and make your practice as secure as possible. And again, depending on whether you plan on coming back or whether you anticipate coming back, that's all very nuanced, and it's something that our department kind of works with lawyers on a very tailored and specific strategy. So again, you have to consider who, what, when, what your obligations are, because I keep landing on that. But ultimately, you want to make sure that that you can, that you can give everybody some peace of mind. Yeah. So it's an option. I'm not saying it's not an option. It's definitely an option, but maybe if you have been with someone for 40 years, you might not be able to have someone parachute in and take things over from another jurisdiction.
Great, thank you. Lynn has another question. Are there any lawyers in Alberta that say, I'll do yours if you do mine?
Yes. Yes. And we have that all the time, especially with well, and I hesitate to say now, especially with lawyers who might be heading, towards retirement within the next 5 or 10 years. COVID has kind of changed that whole dynamic. And we actually encourage lawyers even starting out because of, the fact that they've got absences or they might have coverage or family concerns, other things. We have that where you reach out to someone and I'll do yours, you do mine. But again, things change. So it's nice to have 2 or 3 people to possibly work with on these matters, because I think one of Eleanor's anecdotes was an older lawyer who went into hospital. He did have a contingency plan. He had a junior that was working with him. But then shortly before his health deteriorated to the point where he couldn't accommodate practicing anymore and had to be hospitalized, she had changed her plan. And so she went elsewhere. And then what? So that's when his colleague, old friend from law school, stepped in. So having someone, engaging with you in that way is really helpful. But again, always think about the contingency, right? You never know.
Yeah. Another question is, I don't want to take it too far off scope, but say, for example, if you're like I'm at legal aid, or you're working within a bit of a bigger firm, so it's not as if the files are necessarily going to go outside of the firm or the location that you're working, but you as a lawyer have a client base and you're kind of doing a handoff to other lawyers. What are some of the things that you have to think about? So, for example, perhaps you have to write letters to the clients. It's just a bit of a different context than we've discussed.
Yeah, and if you are at legal aid, I mean, someone's probably going to take the file over, and you can even in Alberta, where we have a certificate system, right? Or it's a different system. For me, it's analogous to a certificate system coming out of Saskatchewan, where we had the entity and then we would refer files out. But in Alberta, you get the file from legal aid, you're on the roster. Maybe you know, when that happens and you've got to go somewhere, or you're you know, the practice is closing, the files go back to legal aid. But you still want, even if you're in a firm, or if you're at legal aid as a proper entity, maybe you still want those files as well papered as possible, right? You don't want anything, you want that master file list so everything can go over to the lawyer taking over as cleanly and smoothly. There will be no court dates missed. There will be no instructions that have been, you know, inadvertently misconstrued or misperceived. Everything needs to be as aligned as possible. Similarly, if you're transitioning within a firm, you want to have your billings to the degree that you have autonomy over them, you want all that aligned too. All of those things have to be just as clean as possible, and that's where the practice management comes in on the front end, and the invariable practices where you can say, I can sleep at night, I have a list of all my files, I know the next step, last step, nobody's going to be in custody because I forgot, you know, to note something on a file, right?
And I was thinking as well, for a lawyer who agrees to take over in the event that something happens, that's a great source of referrals as well. And especially if you're starting out, that might be a great way too.
Yeah. The manual, the templates in the manual can also help sort of deal with the sample agreements, like I meant to mention when you asked about, does one lawyer say I'll do it and you do it for me? There are some sample forms in there, and again, Alberta specific, but generally you get the idea. So there are ways to navigate that too. Same thing with the locum process.
Okay, I'm not seeing any further questions, and I think I've asked just about every question that I had, so I'm not sure if there's any final thoughts from either yourself, Donna, or Eleanor.
No, we're here if you have questions after, I mean.
Great. Okay. Well, thank you so much on behalf of the Law Society and all the panelists, or the participants rather, who have joined today. Thank you so much. We really appreciate it, and it was quite an informative presentation. So thank you both, and thank you, Kendall, as well, for your assistance.